Is there such a thing as a slam dunk Social Security disability case? I'm Jonathan Ginsberg, and I'm a Social Security disability attorney. And recently, one of my YouTube viewers responded to one of the videos I had posted, basically talking about what attorneys do, and his comment was, I don't need to pay an attorney $6,000, which is actually 25% of his past due benefits with a cap of $6,000. I don't want to pay $6,000 to an attorney when my case is a slam dunk. And my response to that is pretty simple. There ain't no such thing. There's no such thing as a slam dunk in Social Security disability. And I've been doing this for 25 years, and I can tell you that I've seen cases. It's unbelievable to me that cases get turned down at the initial and recon, and realize if you're at a hearing, you've already been turned down twice. I've had people turned down by the adjudicators for symptomatic multiple sclerosis. They've been turned down for being brittle diabetics who have no control of the blood sugar at all. People with multiple herniated discs that can barely walk in a wheelchair. I've had people wheeled into hearings on a stretcher. They're in such bad shape. I've had schizophrenics that have completely lost touch with reality. People that are just, you can't imagine how they could get turned down. And you get to the hearing, and again, I think most judges want to be fair, but you have to realize a judge is going to see you for 45 minutes, and your case better be ready for that judge. And what I mean by that is that when you get turned down at reconsideration when you request a hearing, basically, from that point on, you have the full responsibility for updating your medical records. So if you think that Social Security is going to update the medical records, they won't. So if you get to a hearing and it's been a year and a half since your recon denial and there's no records updated, the judge is going to look at a file and see there's a year and a half gap. Well, that's not going to work real well, because judges don't like gaps in treatment, and no matter what you say, if there's no records, judge is going to turn you down. And nowadays, they're closing records at the end of hearings unless there's a really good reason for it. So it's very possible that if you have not updated the record, you go to your hearing, the judge is going to close the record, make the decision based on what was considered an initial and recon, which was a denial, and he's going to essentially affirm that denial. So there's a lot of things you need to know how to do that attorneys do. And again, I'm not saying that this should be this complicated, but it is. You've got to know how to use the barcode system to get your records updated. You've got to know about the 5-day rule, that you can't submit records within 5 business days of your hearing. You need to know how to cross-examine a vocational witness and to pose additional hypotheticals to the vocational witness, and understand what the vocational witness does and who he is. If there's a medical expert, how do you cross-examine a medical expert? I think that people get really confused when this gentleman was talking about a slam dunk. He's talking about his medical record. And again, you can have a really, really significant medical problem, multiple herniated discs or congestive heart failure or terribly bad diabetes, but you're not going to win unless you can prove to the judge that this severe medical problem limits you from working. The issue in your disability case is, do I have the capacity to do a simple entry-level job? It's not about could you do your past work. It's not about could you do part-time work. It's not about there's no jobs that I could do in my area. There's nothing I'm trained for. Wouldn't make enough money. If there was a simple entry-level job like being a greeter at Walmart or being a ticket taker at a movie theater, if such a job was available full-time, could I do it? And does the medical record show I couldn't do it? And that's what you have to prove. And I think people get confused about that focus on the medical, not about the vocational implications. So there is both a philosophical issue you've got to deal with, what you're trying to prove. You've got to understand the theory of the case you're using. Are you trying to prove you meet a listing? Do you meet the grid rules? Are you arguing functional capacity? You've got to do all this in 45 minutes. So again, I just don't think there's such a thing as a slam dunk. You would have to assume that the judge is going to do your work for you, is going to see all the things in the record and make a decision without your contributions and your help. Again, what an attorney would normally do. I just think given judges the work schedule they have, to assume the judge is going to go above and beyond and basically make your argument for you, I just think that's a really, really risky thing to do. So yes, $6,000 is a lot of money, 25% of your benefits, a lot of money, but 100% of nothing is nothing. So my feeling is that there's no such thing as a slam dunk, and don't assume the judge is going to go above and beyond to spend the time to develop your record and to prove that you're disabled when you're really only giving him raw materials. And as attorneys, we digest it, we translate is a good way to put it. We translate the medical record into specific work limitations. That's how we earn our money. That's why an attorney can be very, very useful to you in your disability case. I'm Jonathan Ginsberg. If you have any questions, please reach out to me. My website is ssdanswers.com. I've got a free Secrets to Winning Disability Survival Kit, or you can request a case evaluation. I've also got a podcast at ssdradio.com. I'm happy to share what I know with you. Again, and I want you to be better prepared as a claimant. I still don't think, even as prepared as you may be, you can watch all 300 plus of my videos, but then again, that's not the same thing as having experience trying cases, understanding what judges need. Jonathan Ginsberg again, wishing you the best. Thanks a lot. Hi, this is Jonathan Ginsberg, and I hope you found this video helpful. If you'd like to know more about how to win your Social Security disability case, I'd like to invite you to download my Secrets to Getting Approved Early Survival Kit that I created just for people like you. Currently, I'm making the Survival Kit available at no cost, and I encourage you to grab your copy now. Some of the topics I cover include: how do I know if I have a case? Is it the right time for me to file my claim? 9 common mistakes that can doom your case. The 3 must-have arguments you use to win your case. And a topic that every disability claimant wants to know: how to avoid trick questions from the judge. If you or a loved one need to win Social Security disability benefits, you'll find the Survival Kit essential reading. Download your Survival Kit right now and at no cost. Just visit ssdanswers.com/survival and sign up. It's that easy. Please act now. And as always, I wish you the best.